Hello everyone, my name is Rishabh Singh Pawar, and today we are going to discuss the definition clause of Code of Civil Procedure, under which first of all we are going to discuss about decree. So what is decree? The definition, first of all, we will read the bare provision of the decree which has been provided under section 2 subclause 2 of the Code of Civil Procedure 1908. Okay? So decree means the formal expression of an adjudication which so far as regard to the court expressing it conclusively determines the right of parties with regard to all or any matter in the controversy in the suit and may be either preliminary or final. It shall be deemed to include the rejection of a plaint and determination of any question within section 144. Okay. So now I have read the bare provision. Now we will discuss it in extensive manner. So what is a decree? First of all, there is a formal expression from the court. Okay. Whatever your matter is, in that the court will first of all give any kind of judgment or any expression written on the document. So the thing which the judge will prepare, that will be called formal expression. Okay. Writing anything on the paper like judgment or order, not order, but judgment. Okay. So after judgment, the decree is prepared. So first of all, in decree, we need an formal expression. Okay. Now adjudication means the conclusion of the suit. And next thing, the court expressing it conclusively determines the right of party. Conclusive means it means it is on the final stage of the case. Okay. Now there is no more hearing, no evidence, no argument. Okay. All the rights of the both the parties has been properly settled by the honorable court. Okay. Now next thing which is important in a decree, that matter in controversy. Okay. So the conclusive determine the rights of party, but regarding what? Regarding matter in controversy. Okay. So next thing is like the decree may be of two natures. Okay. Preliminary or final. Preliminary means like there is need of some more further proceeding into that portion or that decree. Okay. And in final decree, it is final in nature. Okay. It is specifically providing us about final in nature. Okay. Now there will not be any kind of further procedure. It will include only, it will be final in nature, last. Okay. So there are two types of decree, preliminary and final. Okay. And it shall be deemed to include the rejection of a plaint. Okay. Rejection of a plaint has been provided under Order 7, Rule 11 of the Code of Civil Procedure. Okay. So what is plaint? So plaint has been provided under Order 7 of the Code of Civil Procedure. Plaint is nothing but a document which is prepared by the plaintiff and his advocate for asking for their legal rights which has been breached. Okay. In plaint, we provide all kind of details like details of parties, plaintiff, defendant, what is the cause of action, how the court has jurisdiction into that matter, and everything, whatever the remedy plaintiff is seeking into that, we will mention into the plaint. Okay. So now I will go to the Order 7, Rule 11. Okay. So for that, next page. Pause pause. ऊपर से नीचे नहीं. Pause. Pause recording. Pause. So we have come to the Order 7, Rule 11. Like we were discussing about decree. So what is rejection of a plaint? Rejection of a plaint is also known as a decree. Okay. So what are the grounds on which basis a plaint may be rejected? Okay. So the plaint shall be rejected in following cases: when it does not disclose a cause of action. Okay. What is a cause of action? It is a bundle of facts which the plaintiff needs to prove any kind of remedy gaining in his favor. Okay. So when a plaintiff does not disclose or provide any kind of cause of action into its plaint, then it will be rejected outrightly. Next, where the relief claimed is undervalued and the plaintiff, on being required by the court to correct the valuation within a time to be fixed by the court, fails to do so. Okay, so relief claimed is undervalued means like the you are filing a case, civil suit, in which in your plaint the original value of your property is above 1 crore. Okay, and there is dispute regarding that property, but you are claiming only 5 lakh rupees of value for the property. Okay, under this condition, what will happen that your property is worth 1 crore, but you are claiming only 5 lakh. And in this scenario, what will happen? You will file another case later on, and it will cause the um, wastage of sources also and wastage of precious time of the court also. So the court tries to take all kind of remedy into single plaint. Okay, so I think you have got my point. Like if you are claiming anything in your suit or plaint, then you have to properly value that case. It should not be undervalued. Okay, and if you have been given the time to correct that valuation of that matter and you have not still did that, under such condition the your plaint will be rejected, and that shall be also known as rejection of plaint is a decree. Okay, that will also be a decree automatically by default. Where the relief claim is properly valued but the plaint is returned upon paper insufficiently stamped and the plaintiff, on being so required by the court to supply the requisite stamp paper within a time to be fixed by the court, fails to do so. In this clause, you have properly valued your suit, like you were asking for 1 crore of valuation and you have properly mentioned about 1 crore. But what problem you have committed? You have not properly stamped your plaint. Okay, under this condition, the court will give you time to rectify your mistake, but still you did not correct your plaint and you did not properly stamp it. Under such condition, also your plaint will be rejected, and that rejection will also be known as decree. D point is where the suit appears from the statement in plaint to be barred by any law. Okay, like if any kind of suit which you are filing in it is properly expressly has been denied by the honorable court or barred by the court. Like I'm making a sale, like in which I have given a supari to gunda of the society to kill someone, and I will give him 1 crore rupees of plot or flat, whatever you can assume. So under this condition, although I'm making an agreement, but what is happening here that I'm trying to kill someone, so it is barred by law. So where from the suit it appears that a statement in the plaint to be barred by law. If it is barred by law, it shall be also rejected by the honorable court, and it will also be a plaint. Next is where it does not filed in duplicate. Okay, this is a fresh amendment which had been made earlier. It was not originally into the Code of Civil Procedure. It was later on added into the Code of Civil Procedure. So what will happen that whenever you are filing any kind of plaint or suit into the civil courts, you need to file it in duplicate. Okay, one copy for judge, that is original copy, one copy for defendant, and one of your own copy that is to be kept with you. That is a general sense. Okay, so you need 2 copies of the suit. And next is where the plaintiff fails to comply with the provision of Rule 9. Okay, so Rule 9 is regarding the plaint, what should be added into the plaint. We are not going to discuss that. Whenever the plaint is rejected on this following ground, it will be considered as a decree. Okay, so now we will be going to इसको pause करना है. So now we are back to our section 2, clause 2 of the decree. So we have discussed about rejection of plaint under Order 7, Rule 11. Okay. Now, what shall include the decree? Rejection of a plaint which has been provided under Order 7, Rule 11, and determination of any question within Section 144 of the India Code of Civil Procedure. Okay, 1908. So 144 talks about restitution of the suit. We are not going to discuss it in this session. And but next is what shall not include the decree. So under what condition decree will not be concluded? These are, first is any adjudication from which an appeal lies as an appeal from an order. Okay. So when any adjudication, like any kind of judgment has been passed, but it is subject to any kind of appeal for 90 days, for 3 years, whatever may be the numbers for that. But whenever it is subject to appeal, it will not be a decree. And next is any order of dismissal for default. If you have committed any kind of default in filing your plaint, it will be also converted in, it will not also convert into decree. Okay. Now we have two things more, decree holder and judgment debtor. Decree holder is a person in whose favor the decree has been passed, and judgment debtor is a person against whom a decision has been made. Okay, so this will be all for today. We will meet in next session. Thank you.